Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, give your attention, and you shall be heard. Please be seated.
Good afternoon, all. Welcome to the Appellate Division First Department. Oral arguments for today, April 25. So you're all familiar with the spiel. Only ask for the time that you need to get at the salient points of your argument. Keep in mind that this is not a perfect world. So therefore, again, I'm sure you'd like to be here all day arguing, but we're not going to do that. So please, only ask for the time you actually need to get out the salient, important points of your argument. Also, keep in mind, we have read your briefs. We are fully familiar with your arguments. People v. Lawrence Elliott.
Appellate asks for
5, 1, and 5. A matter of our children. That matter is submitted. Feehan versus Consolidated Edison.
Good afternoon, Your Honors. Rick Soto for the appellant. Request 4 and 1.
Con Ed? Do you have a cross appeal? You have a cross appeal? I do not. So 4, 1, and 4. Entech Engineering versus Duberry Engineers.
Appellant 5 and 2, please.
Respond in 2 minutes.
5, 2, and 2. Toucey or Toucey versus the City of New York. You represent?
the respondent, and happy to answer any questions the panel has. Otherwise, we can rest on briefs.
Please, thank you very much. That matter is submitted. People v. Luis Rivas Grion. That matter is submitted. Hovie Star Contractors.
Plaintiff's appellant request 5 and 2.
I do not see any, hello? There's no respondent on that. Did you still wish to argue against yourself? Okay, 2 minutes. Glen Oaks versus the City of New York.
For appellants, Your Honor, request 7 and 2.
727. Bradley versus St. Barnabas Hospital. 425. DirecTV versus Nextstar Broadcasting.
For the appellant, I'd like to introduce Mr. David Barnabas of the bar of the state of Texas, who is admitted pro hac.
I do not see, oh, there you go. Yeah, so like when the case is called, you should probably get up so we know you're here.
Your Honor, for the respondent and cross appellant, 16.
8264. Irani v. City of New York.
For the petitioner, appellant, 6 and 2.
So we're going to do both matters. So you're requesting 6 and 2?
For respondent 3,
623. Narramore versus Mount Sinai Health. That matter is submitted. Taxi Tours versus Go New York Tours. That matter is submitted. So today we are joined by Mr. Andrew Aldis, Mr. Patrick Duldy, from Kaufman, Borgeste, and Ryan. Is that correct? Yeah? And you are with a group from Lloyd's of London from the UK. Is that correct? Excellent. And you're on a tour of New York, and you decided this is going to be part of your tour, other than the Statue of Liberty, et cetera. You decided to come to the Appellate Division, right? Okay. So, attorneys, we are going to be on our best behavior, okay, because we are representing the United States. Thank you. People v. Lawrence Elliott. I was reminded to note that Judge Pitberg is on video, so we are actually a panel of 5. Thank you. Whenever you are ready.
Good afternoon. The law requires a hearing if a 440 claim raises issues of fact. Here, Mr. Elliott's pro se papers amply met this very low standard. Every indication in the record suggests that he will likely be sumpted, and he has stated under oath that he wouldn't have taken this plea had he known of that possibility. Given these facts, we need a hearing.
Counsel, what about the fact that he's not even eligible for parole till 2030 and not even at all clear that he'll get parole at that time? How likely is it really on this record that he actually would incur this potential consequence?
Well, when he will get parole and whether he will be paroled are questions of fact that have to be resolved via hearing.
Right, but you have to find that something's not just speculative, that it's a real concern, and those are all factors that are undisputed, that he's not even eligible for parole until that year, and that very few defendants actually get some consequence.
I would highly dispute the latter, Your Honor. The statistic that very few defendants are sumpted, and we say this in our papers, is incredibly misleading. It includes an enormous number of people who are set aside at the beginning.
Why don't you address the first part first, which is that he's not even eligible for parole till 2030.
If we want to come back here in 20 years and litigate this then, it's not good for my client, it's certainly not good for the people, and it's really, really not good for the complainant. There is no call to wait for 20 years.
I'm not suggesting you wait. I'm saying those are undisputed facts that go to the issue as to whether any of these consequences are real concerns or more speculative concerns.
Again, Your Honor, if the only question is waiting to see whether he will get parole, one, that's a question of fact that we can resolve via hearing now. We can present stats, the people can present stats on the likelihood of when he will get
Well,
parole.
the people did. They stated that fewer than 5% of all eligible sex offenders, that these proceedings are brought against less than 5% of all eligible sex offenders.
I'm sorry, Your Honor, the justice directed me to the question of how likely he is to get parole. On the question of how likely he is to get sumpted, if OMH makes the referral, there is almost an 100% likelihood that he will be civilly committed. And every indication in the record here, his Stat 99, his history of sexual offending, the very serious allegations against him suggest that it's not just a question of fact whether he will get sumpted, which is all that is required for a hearing, but that he will very, very likely be sumpted.
Well, that's the issue, is whether or not there should have been a hearing to determine whether or not there should have been a hearing.
Correct, Your
And
Honor.
so if everything was, there was a sufficient presentation on paper, then why is a hearing necessary? Why would a hearing be necessary?
We are not asking the court to withdraw Mr. Elliott's plea right now. We are saying that he has presented sufficient facts to warrant a hearing. Only if there are no facts in dispute is a hearing not required. There are certainly facts in dispute here.
In this case, he potentially had a sentence of 25 to life, potentially.
28 to life.
Okay. And he opted for 13 years, correct? The fact pattern here is, so for him to have made that kind of decision and then be concerned that he would be subject to civil confinement under these circumstances, given the nature of his crime, which is very different than People v. Balsarac and the others where, say, someone sentenced to about 1.5 years with the potential of having a lifetime civil commitment. That sounds like a real concern for the defendant in accepting a plea, markedly different than the fact pattern here.
Great question, Your Honor. Underlying that question, I count at least 5 major questions of fact. The first and perhaps most important is that this court has made clear that the question of whether a defendant would or would not have taken the plea is a credibility question that demands a hearing.
Well, we often affirm, we often affirm these determinations being made without a hearing. It's not that we always require a hearing in these type of determinations. I'm not sure what it is you're stating right there.
I'm sorry, Your Honor, I
We
didn't...
often affirm when there's not a hearing. We don't always require a hearing. And you keep saying if there's any issue of fact, but I don't know if that's the standard, any issue of fact. It's whether it's speculative.
No, First, Your Honor, I don't know of any case where this court has addressed a SOMTA claim and denied a hearing. I don't think it has.
Well, no, but
Two.
we've addressed issues, and that was my question previously. We've addressed issues in People v. Jones. The Court of Appeals in People v. Jones stated that where there was no inclusion in the moving papers, sworn allegations that tended to substantiate defendant's assertions that the prospect of an issue would have prevented he or she from taking the plea. That's what I was trying to get at previously.
That may have been the case in Jones. Here, there is ample reason to believe that he will be SOMTA'd and he would not have taken the plea otherwise. I would like to get back to the question
We can
about...
get back to that on your rebuttal.
Oh, I'm sorry. There's no light, Your Honor.
Oh, I'm so sorry. I thought it went off. I think because I thought it went off.
I didn't see a white light
It
or...
did. I think you were still talking when it went off. That's you. Maybe you didn't see it, but trust me, it went off.
Okay, thank you.
Thank you.
May it please the court, Alex King for the people. The lower court providently exercised its discretion in
Also, the
summarily.
defendant says that he would not have taken this plea had he been advised of this. Why isn't that enough?
Even assuming for the sake of argument, Your Honor, the defendant was ignorant of SOMTA, there is no reasonable possibility that knowledge of SOMTA would have prompted him to reject what was a very favorable plea offer. Defendant is a college-educated man, and he was sufficiently rational to recognize that there were essentially two possible outcomes here. He could be convicted after trial and surely spend the rest of his life in prison, or he could plead guilty and retain some hope of being released decades in the future.
He could still spend the rest of his life in prison under the guilty plea, correct?
It is possible that he will be paroled. As defendant says himself, it's a very remote possibility, but that was his decision to make, and he made the sensible choice of pleading guilty and accepting the favorable plea offer. It makes sense that defendant says that parole is a very remote possibility, given that he is a serial rapist and he committed a heinous crime while he was at liberty pending sentencing in an unrelated case for selling drugs. And even setting parole aside, the outcome of the Byzantine SOMTA process, that's defendant's term Byzantine, cannot be predicted decades in advance because we cannot know what defendant's mental condition will be decades in advance. That is exactly why the cases in this area, like Balsarac and Bellamy and Harnett, focus on whether the defendant has yet been placed into commitment proceedings, which obviously this defendant has not been. If there are no questions.
Why do we not look, however, to whether or not the defendant, in fact, would have taken the plea in terms of the consequences that he faced?
There's no reasonable possibility of the truth of his assertion that he would have rejected this plea if
Well, he says, I mean, he asserts that there are. That he asserts that had he been made aware, he would not have taken the plea. So my question is, why isn't that sufficient?
He does assert that, Your Honor, but that assertion goes against common sense. He was willing to accept a plea offer that could result in him spending the rest of his life in prison. In fact, he says it's a very remote possibility that parole will ever be granted. It doesn't make sense that just because, again, this is assuming he was ignorant, but just because he had known, if he had known that SOMTA was a possibility, he would have rejected this very favorable plea offer. I'll say further, we don't have much reason to be confident in the truth of this defendant's assertions. His moving papers are replete with blatant lies. He continues to blame the victim of his offense. He says it's a conspiracy against him, and he also fails to accept responsibility for all the crimes I believe he has committed in the past.
At the time he committed the crime that he was convicted for here, he was a level 3 sex offender, correct?
I'm sorry, Your Honor.
Was he a level 3?
Was he, I believe he was, yes. He was also registered in other states for other sex crimes he had committed elsewhere. If there are no questions, we ask that you affirm. Thank you.
Thank you. The light is it beeped, but it did not actually go off, counsel. So there we go. My apologies. But it did beep when you were at 5 minutes.
I appreciate it. I'd appreciate a little leeway because I did.
Not a problem.
Respondent is asking you to resolve a credibility question. You heard him say, we can't credit my client. There's no reasonable possibility here. Reaching that conclusion would require ignoring an unbroken stream of precedent from this court and the other departments, saying the question of whether or not someone would have taken a plea is a credibility determination that has to be resolved in
So
a hearing.
he was ultimately sentenced to, he accepted a plea to 13 to life?
Correct.
He was facing 25 to life. Is that
He was
correct?
facing a maximum of 25 to life, I
Maximum
believe that's
25 to life. And so this was on the eve of trial.
right. A jury had already been sat.
Jury had been sworn in already. This is the eve of trial. He's made this, this offer is made to him. He accepts the offer after speaking to his attorney about this. He has these priors, the prior sex offenses. Go ahead.
If I may, Your Honor, his sworn allegations are that he made this decision after he felt completely abandoned by his attorney for not doing any of the investigative steps that he asked for. That's in our papers.
Well, that's all well and good, but my point is, so in terms of credibility, we are to believe, therefore, that even though he would have been facing a max of 25 to life, which he may have been sentenced to following trial, he makes this determination the eve of trial. These priors that he has, which again would go into the sentencing, that but for his being told that he would be subjected to this, he would not have taken the plea.
You, this court,
That but if he had been told that he would be subject to this, wherein the likelihood was iffy, and would also be again 20 years hence or whatever,
I think here's the
15
heart of
years
it.
hence, he would not have taken the plea.
I think here's the heart of it, Your Honor. You said, are we to believe him? That is a question for the lower court.
Well, no, that's the question in terms of, yeah, exactly. That's a credibility determination. And so why is it that you're arguing that Supreme Court did not make that credibility assessment?
It is a credibility determination that this court has said over and over and over, please refer to my papers, has to be resolved at a hearing. Two very quick things, if I may. The standard here is a question of fact. We cite, that's black letter law, Your Honor. We cite case after case in our papers. And finally, to Your Honor's question about why not wait, OMH is more likely to make a referral for those defendants who are accused of more serious crimes, who have more serious sexual histories.
This is in your papers?
It is, Your Honor, but if I may, I'll finish up quickly. Those defendants are more likely to be SOMPTed. To require for them to wait for longer is going to turn the likelihood of SOMPTed confinement on its head. Those people less likely to be SOMPTed may bring these claims earlier. Those more likely to be SOMPTed will have to wait for decades and decades. It serves no one's interest to follow that line.
Thank you.
Thank you.
Thank you both. Seahan versus Con Ed.
Good afternoon, Your Honors. Central to the lower court's ruling dismissing the appellant's claim for prima facie court in the complaint and denying leave to amend the complaint was...
Counsel, for prima facie tort, would you agree that a critical pleaded allegation must be that in this case, the defendant exhibited disinterested malevolence as the sole motivating factor in demoting your client from his higher position to the lower position and all the other damages that you claim took place? Do you agree with that?
We recognize that, Your Honor.
Okay.
We agree with it.
So how can you claim that you pleaded that, because I didn't see it in the complaint, as the sole motivating factor, particularly when we have a situation where there was a complainant who charged him with discriminatory conduct? We're not talking about like in an employer-employee relationship where the employer says, I don't like this guy, we're gonna set him up. We have someone, a non-party, filing a grievance against your client for all kinds of stuff as a superior in their work relationship. She was the sole female in this IT unit. So how do you work that out here? How do you feel that on this record you met that pleading standard?
Within the complaint goes ad nauseum, exhibiting examples how within the foundational report that was the basis for the demotion of Mr. Fian was inaccurate, was false, and was known to be inaccurate and false to Con Edison when they demoted Mr. Fian.
So, counsel, I'm looking at the complaint. Could you point me specifically to where in the complaint?
So in the
this is laid out?
second amendment, I'll point to the second amended complaint.
Okay.
Your Honor. Paragraph 18, which is at A331, enumerates the specific examples, the core bases, conclusions reached in the ODI report that formed the basis for the decision to demote Mr. Fian. Paragraph 23 points to the letter that Mr. Fian subsequently sent to Con Edison
Paragraphs 23?
in the second amended complaint. And
Yes.
that is at A332. It points to Exhibit B, which was attached and incorporated into the second amended complaint that goes ad nauseum through testimony and other material that had been discovered during the related federal litigation that pointed to the inaccuracies of those ODI findings and to the knowledge that Con Edison had of the inaccuracies and the falsity of those findings. By way of one example, in paragraph 46 at A46, which is Exhibit B in the letter, Mr. Fian quoted ad nauseum testimony from one of the individuals who was at the panel that demoted him that admitted that they knew that the core allegation that he had been involved in denying Mr. Aselli overtime simply was not possible because he was in management and management had no role in that.
Where's the connection, though? It's not enough to show that the report was faulty in some way or that there were errors in the fault. You have to show that they're relying on that report solely to harm plaintiff's career, that that was their only motivation to make out a prima facie tort. And where do you allege that? Not that the report was faulty or not faulty, but that was the sole motivation for why they demoted the plaintiff.
We allege that throughout the complaint. The paragraphs in which we allege that are pointed to in the complaint. At its core, we're at the pleading stage of this litigation, where there's only so much we can plead at this point. But
You allege in the complaint that defendant relied solely on the report to harm your client?
Yes, Your Honor.
Okay, so on rebuttal, you can point me to those sections. Thank you.
Good afternoon, Your Honor. Sylvia Janine Conley for Consolidated Edison.
So is there anything in the complaint that alleges that your client relied solely upon the report in order to harm the defendant? Excuse me, in order to harm the plaintiff?
No, Your Honor, and that is obviously what we contend, and is that, in fact, there is nothing in the complaint. Appellant's counsel just pointed to paragraph 18, which actually discusses the Office of Diversity and Inclusion report that Con Edison relied on when it demoted appellant. And paragraph 18 actually spells out the 5 reasons why they demoted him.
Right, the claims by black employees, claims by that Mr. Astley, or Accely, was treated less favorably than others, that the plaintiff tried to interfere with Mr. Astley's overtime. Performance evaluations were conducted favoring white employees. Both white employees and black employees have qualified the overall behavior, et cetera. That I see. I don't, and I see the conclusion from ODI, in the ODI report in paragraph 19, but I don't see anything as to your client's reliance to the detriment of the plaintiff.
Agreed, Your Honor, and we don't see anything there either, which is why we do feel appellant has failed to make out any claim for a prima facie tort. He has not showed the disinterested malevolence that is necessary, and that other cases where there is malice and no justification to allege a prima facie tort. Here, there was certainly a justification that came out of that Office of Diversity and Inclusion report. That report was by an independent group, the Office of Diversity and Inclusion, and their purpose is to determine whether a complaint can be substantiated.
Now, there was testimony by Con Ed employees that the plaintiff was an effective manager, that there was one, I think Ms. Kong stated that she didn't see any discrimination on his part. There was also testimony as to his exact responsibilities in terms of performance evaluations, allocating overtime, et cetera. What about that in terms of you relied only on the report and did not rely on other evidence that was submitted or submitted to you?
I think the Office of Diversity and Inclusion said that they did incorporate all the evidence that came to them. Obviously, they weren't able to interview every witness, but that in and of itself does not change the fact that they came to the conclusion that they came to, which is that the racial discrimination allegations were in fact substantiated based on that paragraph in the complaint, paragraph 18, which spells out the overtime that Mr. Feehan was treating people differently, was giving preferential treatment to white employees, was giving higher scrutiny to black employees, and those particular facts.
Counsel, were there any allegations that General Manager Teresa Kong and Con Ed Vice President Robert Boyle were involved in generating the report?
There were no
Nothing.
allegations
And
of
they
that.
were part of the decision-making process that, as you described, took in all the evidence in addition to the report, correct?
That's correct. And
So we're talking about key players for Con Ed that were not necessarily based on this fact pattern, solely motivated to rely on the report to hurt this guy.
That's correct, Your Honor. Totally separate. They were not at all involved in the report, and it's Robert Boyle who actually made the final decision to demote the appellant.
Well, paragraph 8 says Feehan, Kong, and Robert Boyle rejected grievances that were submitted.
Ms. Kong recognizes that she rejected grievances that were submitted. Those were totally based on the performance evaluations. She says she did not know all of what was submitted for the actual investigation in the report, which was solely done by the Office of Diversity and Inclusion.
Thank you.
Thank you, Your Honor.
Just if I could briefly address the court's inquiry about where in the complaint it states that the defendants relied on the ODI report as the sole basis to demote Mr. Feehan. And I would just point the court at A3330 to paragraphs 11, 12, and 13, paragraph 13 in particular. On or around June 5th, 2019, Mr. Feehan attended a meeting with Mr. Boyle and Ms. Kong, as well as a representative from Con Ed Human Resources, Ms. Angela Adjicum. During this meeting, Mr. Boyle informed Mr. Feehan that ODI had found Mr. Feehan to be in violation of Con Ed's EEO policy, and that as a result of this finding, Mr. Feehan was being, and then he goes on to list the deleterious consequences of that decision that was based solely on the ODI, Office of Diversity and Inclusion's findings that were summarized in that report. And we do, at paragraph 18, summarize the core conclusions of that report, but then further down in the complaint, at paragraph 20, we assert that those conclusions were false. And then in paragraph 23, we point to Mr. Feehan's letter where he goes ad nauseum in detail what from the record in the federal litigation established that it was false. And I might add that as part of Con Edison's defense in that related federal litigation, they refuted their own ODI report. That is in that record. That is in the letter that Mr. Fian sent to Con Edison asking them to reconsider the decision to demote him.
Thank you. Thank you both.
Thank you.
Entech Engineering versus Duberry Engineers.
Good afternoon. May it please the court. Jonathan Schaub for the plaintiff appellant Entech Engineering. The issue on this appeal is whether Virginia law applies to Duberry's claims for attorney's fees.
But how do you reconcile the fact that until this point, you were saying it's New York law?
Well,
You said New York from the beginning. The lower court actually found and agreed with you that New York law applied because there's sufficient nexus with the defendant with New York to satisfy it.
And let me just say, you were not only saying it was New York law, you were vehement in all of your papers, all of your submissions. You stated that New York law applied. Now, all of a sudden, Virginia law applies.
so two responses to that. The first is judicial estoppel only applies when you prevail, when a litigant prevails, and that means you've obtained a benefit or relief. Entech received no benefit or relief in this case. It lost its motion for summary judgment. Duberry's motion for summary judgment was granted, and all of its claims were dismissed.
So you won your argument that New York law should apply. The court applied New York law in dismissing the claims.
We don't think that that is what the record reflects. Now, if you look at the summary judgment,
What record reflects? We, in our decision, stated that New York law applied.
Your Honor, I actually think it's a little bit more nuanced than that.
Well, since I think I was on that case, if I'm not mistaken, I thought I was on that case.
Your Honor, you said it was.
I think
Can I
we
also
may
just
know.
add, separate and apart from collateral estoppel, or it's law of the case. I mean, judicial estoppel. It's
So
law of
to-
the
to-
case that we held that New York law applies. When you appeal that very issue, we specifically made that holding. Now that's the law.
So again, I want to respectfully push back on that. This court actually found that the pay if paid provision was enforceable under either New York law or
Because
Virginia
that's the
law.
conflict analysis, but we clearly agreed, and you clearly argued to us that New York law applies, and we agreed with you.
And I'm looking at the decision, which again, I was a part of, and it was stated that New York law applies. And my colleague is correct. What we talked about was the choice of laws in terms of the paid for pay.
Right, but then there was never, if we look at the decision, the first thing that the court had, there's a choice of law provision. Everyone agrees on that. Then the Supreme Court below said that Duberry failed to carry its burden of establishing that it was enforceable. The court then also found that Entech failed to establish its burden, that it was unenforceable. So instead, the court said, it looked at the conflict of law analysis and said, I don't need to perform a conflict of law analysis in this case because there is no conflict, and then went to and proceeded to analyze every claim and defense.
Are you talking about Supreme Court, or are you talking about this court?
Both courts. That was the decision. It then went to apply Virginia law and New York law to every one of the issues. So on that basis, we don't think that it was ever affirmatively determined that it was New York law. It was the question.
I think what happened was Supreme Court went out of its way to discuss both so that there would be no misunderstanding as to New York law, Virginia law, but came down that New York law applied. We said New York law applied. So you want to move on to your next point?
Then if this court says that New York law applies, then
For the second time.
the Duberry claim is still not valid, and they're not entitled to attorney's fees under this court's decision in Vertical Computer Systems versus Ross, because it's not enough to assert a claim for attorney's fees in a wherefore clause, which is the only place they sought those attorney's fees. So even if this court were to find that New York law applies, that's not a sufficient basis for, they haven't adequately pled that claim and are not entitled to attorney's fees on that basis. And that's at 59 AD 3D 205, and it's this court's decision from 2009.
The Nestor versus Britt decision, I'm not sure, are you familiar with that decision?
Yes.
Well, in that particular case, the landlord focused on a 1983 lease and argued, wanted his fees, and then somewhere when he was prevailing, he was a happy person. Then he ultimately lost. when he was reversed by the appellate term, and refers back to a 1970 lease to try and get out from having to pay attorney's fees. And this court, the lower court and this court made it very clear that you didn't have to win, because you raised that point earlier to me.
Right.
You have to prevail in order to be judicially stopped from changing your position. Nestor versus Britt made it very clear that you don't have to prevail, that you can't just switch gears because you don't like what's going on.
So I don't think we switched gears. I think that we followed through with what the court's decisions were. As the legal landscape changed and the decisions were made, our client followed through with that. So once it was up in the air as to whose law applied, and again, obviously the court disagrees, but we would point that this court said that it was the law was enforceable under not New York law or Virginia law. So that, in our minds, says that this was never firmly resolved. The courts ultimately ended up punting on the issue.
Thank you. You have time on rebuttal. Counsel, in your 2 minutes, could you address the issue as to the attorney's fees, regardless of New York law, which we already stated controlled?
Yes, Your Honor. Good afternoon, Your Honor. Stephen Cohen for Tesser and Cohen. The issue on the attorney's fees that was raised for the first time, not only on the appeal, but in the reply brief as to where it applies in New York, is based on a decision, vertical, which is really not applicable, although it's hard to tell from the limited decision that there is. That was a decision in which now was the parent company of Vertical, had a counterclaim, asked for attorney's fees, was awarded the attorney's fees, was awarded the counterclaim, and then in the last paragraph, the court said that now's counterclaim is now moot and was dismissed as moot. And then in the last sentence, it says it didn't have a request for attorney's fees that was part of the integral part of its counterclaim. So I don't think it really applies. There are other appellate division decisions where they say a wherefore clause is sufficient. I'd like to direct you to those since we didn't have an opportunity previously. But Murata versus Blau, which is actually cited by the Vertical Court, 241 AD 2nd 664, provides that having it in a wherefore clause, the request is sufficient. Bank of New York versus Hirschfeld, 59 AD 2nd 976, also says it's sufficient in the wherefore clause. Webster versus Ragona, 40 AD 3rd 1360, also says not even having it in the complaint at all doesn't preclude the recovery. So we don't feel that that's a valid argument that it had to be in anywhere else. The lower court exercised its discretion in granting the attorney's fees, and I would just like to touch on the reason that I only asked for 2 minutes was not to surprise or please the court. It was because there's only one question that needs to be decided here, and that is whether the lower court applied New York law. And the answer is clear. We're here on an appeal of Judge Crane's decision on the attorney's fees, where she says 5 times, very strongly, as your honors have all seen, that Entech previously argued and prevailed on the issue that New York law applies, and plaintiff was successful in persuading the court that New York law applies. It's that scenario where you use a set of facts to persuade the court to go one way, and then later reverse positions for another point. They would like to argue that New York law applies for one provision in the contract, but Virginia law applies for another provision, and the courts and this court's decision on New York court law was that it applies to the contract, not to one provision or the other, so judicial
Thank you.
estoppel applies. Thank you.
Our position is that this issue was never decided. Again, if you go back to the decision, the Supreme Court said that the Duberry failed to establish that the clause was enforceable, Entech failed to establish that it was unenforceable, and then it performed a conflicts of law analysis. I'm looking at the First Department's decision, or this court's decision from 2022, and it talks about New York law in the context of public policy. And that's relevant because public policy is one of the reasons to invalidate a choice of law clause. This court reached the same conclusion that the Supreme Court did, and it did not decide the issue of whether New York or Virginia law applies. Based on this uncertainty in how this case was resolved, Entech, as was its right, as the legal landscape shifted its argument to match what the court had found.
What legal landscape shifted? I'm confused. What was the legal? I mean, if you believe that under the contract, New York law applied, and that's what you argued, what's the shifting of the legal landscape?
This court never resolved the issue because the issue remained unresolved.
We affirmed. We affirmed. So how is that not deciding? And also, if you believe in your position and you believe that you have a strong position and you are correct, I'm still not understanding what the shift in the legal landscape is.
This court found that either New York or Virginia law applied. So since the question was left open, we then argued that it was Virginia law.
Yeah, we're beating a dead horse because, again, that's not what occurred. But thank you. Thank you both. Hovie Star Contractors.
Your Honor, my adversary has...
Yes, I was made aware of that. Welcome. I'm sure that it wasn't intentional because I'm sure you knew that the calendar was called at 2 and not 2:30. But you'll be granted 2 minutes as well. You're welcome.
May it please the court, Dean Cho on behalf of plaintiffs' appellants. An issue here is defendant respondent's argument that we improperly failed to include a transcript of the oral argument before the trial court.
Did you?
There was no transcript ever prepared.
So, well, you are appealing the decision of Supreme Court, is that correct?
Yes.
And the decision by Supreme Court, the judge specifically stated that it was as per the record, the transcript of the proceedings. She made reference to what had occurred during oral arguments, right? During the arguments.
Your Honor, she refers to what as was stated on the record.
As was stated on the record.
However, it was...
So how do we make a determination as to whether Supreme Court was correct or incorrect if we don't have a copy of the record?
Your Honor, if one looks at the docket sheet of the trial court, there was no transcript.
That's because you're obligated as the attorney, if you want to appeal, to order it, to contact the court reporter and say, I am appealing, I need a copy of the transcript so that we can review it, or else how can we possibly determine your appeal?
After this argument was made, we contacted the court reporter's office. There was no record of any argument. There was never any court reporter identified, no instruction for anybody to order the record. That's why there is no transcript. But the trial court...
The court doesn't have to, though, say order the transcript. You have to know as an attorney that if a judge issues a decision on the record, that you have to then order that transcript if you have any desire to ever appeal that determination or enter a judgment or do anything further with respect to the decision.
And I would think, especially if the decision is adverse to you.
Yes, but there was never any reporter identified.
Was there is your argument that there was no reporter in the room, that there wasn't a reporter there?
I have no knowledge that any reporter...
Then why didn't you say to the court, you can't do the decision on the record, there's no court reporter here?
How does the court refer to the record if there's no record? I mean, that doesn't make any sense. And so then why not say something, as my colleague just stated, why not say something to the judge as to if there's no record, how is it that, you're referring to the record?
I've participated in many appeals. They've always identified the record. The court reporter gets your information, sends it to you.
So, counsel, did you represent the plaintiff, your client, the plaintiff at these arguments?
Yes, I did.
And was there a reporter there?
This was over the computer. It was a Zoom argument.
Was there a reporter?
None was identified. None stated anything. None asked for the caption or the spelling of the names of counsel.
You'll have to ask the judge for a decision.
Yes.
You'll have to go back and ask the judge for a decision.
If that
creates an appealable record.
Right.
Yeah, but the judge did give a decision.
But we have nothing to review. We can't review without, if she's articulating that there's something she relied on that we don't have, we can't review it. So you have to go back to that judge and say, there's no record.
So we'll go back and then we can...
Well, we're not giving advice as to what you should or should not do.
Correct.
We're just making observations as to the fact that we don't have a record from which we can render a decision.
Well, there is a record in terms of the arguments made by each side. The other side...
We don't have a record as to the basis for the judge's decision. So therefore, we cannot make a determination as to whether she was correct or incorrect in her application of the law to the facts presented. Thank you. Yes, you have 2 minutes. Is there anything you'd like to say?
May it please the court. David Wander of Tartar, Krinsky and Drogan, counsel for the respondent. We cited in point 1 of our brief where we addressed the issue of no transcript. We cited...
Are you aware of a transcript?
I've never known of there not to be a transcript. And the case we cite...
Were you present on this Zoom call as well when the... Yeah. Did you see a reporter?
I always assume there's a court reporter whenever I go to court.
Listen to my question. Did you see a reporter? Or was there any statement that there was a reporter present?
Oh, I do not recall that. I was focused on the judge, and I do not have any recollection one way or the other. I just assume every court hearing in a matter like we had has a court reporter, and the beginning of the decision refers to for the reasons in the record or stated. So I assume there was one. I don't know of a case I've been to in a motion.
But you acknowledge that there's no record now on appeal that we could render a decision.
Right, and we cited the Ninth Space LLC versus James Goldman, which is a case from this court, which says, preliminarily, we note that the record on appeal from an interlocutory judgment or order must include, among other things, the transcript. So that was, I believe it's a gating issue for this matter. And if I may, if Your Honor would like me to proceed.
No, that's quite a lot. Thank you very much. Thank you both.
Thank you.
Glen Oaks versus City of New York.
May it please the court, Randy Mastro for appellants plaintiffs. Your Honors, this is not a case about supporting measures about climate change. Our clients, 2 small cooperative associations, one in Queens, one in Manhattan, they invested in things like solar panels and other measures to comply with what was then existing state and city law. But in 2019, New York City abruptly and dramatically departed from past practice in conflict with state law, imposing mandatory requirements with huge penalties for noncompliance. And that this all had to be accomplished by 2024, pulling the rug out from under these 2 associations.
Specific legal issue that we have to decide?
Yes.
Which is the preemption issue and whether or not there is field preemption in this case?
Yes.
Where
Thank
the
you.
case should go.
Thank you, Your Honor. I was setting the table, and Your Honor has now gone right to the meal.
But we're familiar with the case, so we're anxious to hear your arguments about preemption.
So, and we're not even really at the point of whether it is for sure preempted by state law, although I think state law is quite clear.
Well, let me ask you a very specific question. In the context of preemption, and what's the difference in the way we'd analyze it on a motion to dismiss, which this is, versus a motion for summary judgment? What difference would there be between those 2 scenarios in terms of how we decide the preemption issue?
Well, Your Honor, I think that it's a well-pleaded allegation, and therefore we have the right to go to discovery to further establish that obviously the state intended to preempt the field.
So if the main issue in this case is whether or not the state intended to preempt, which it is.
Correct.
That's not like a typical case that goes to the jury and the jury looks at all the evidence and decides. The court ultimately has to decide whether or not there's preemption. So based on that nuance, which is different than most other cases, what, again, is the distinction between what we're trying to decide in the motion to dismiss as opposed to what we'd be deciding in a summary judgment motion, since we ultimately have to be making that determination about the legislature's intent?
Understood. And Your Honor, the principal distinction is this. The lower court not only decided as a motion to dismiss, but it applied the Jansen case, which was a summary judgment case, incorrectly. It applied it as requiring there has to be a direct conflict.
Okay, assuming we're talking about field preemption and not
Yes,
conflict preemption.
correct.
And that the court was addressing the standard of conflict preemption in that statement. And we're not, I'm asking you specifically about field preemption, which again goes to the question of the legislature's intent. What different evidence would there be on a motion for summary judgment as opposed to a motion to dismiss?
Your Honor, we would have the opportunity through discovery to develop both what state legislators intended when they passed what they called in the preamble, findings, and declaration, a statewide comprehensive program, and we would be able to take discovery of what city officials understood about state law and whether they were violating it. So that's something we don't get on a motion to dismiss, but on a motion to dismiss, you have to look at the pleading itself. The pleading itself, Your Honor, it couldn't be clearer that we've met the pleading standard to be able
Right,
to.
but this is not a case where you're just looking at the pleading, because obviously you have to look at the legislation itself.
Correct.
To determine what the legislative intent was in terms of field preemption. So you could say anything you want in a pleading, but still we'd have to look to the statute to determine whether preemption exists.
Yes.
Isn't that how we look at it?
Correct. So let's look at the statute.
Okay, let's look at the
So
statute.
just picking up on what my colleague raises here, if the CLCPA, the state statute in force here, begins with the notion of the legislation will create a comprehensive regulatory program to reduce greenhouse gas emissions. That sounds like it's a pretty statewide type of.
Correct, Your Honor. We didn't get to the point where we could move for judgment, but on the face of the statute, Section 1, statewide comprehensive. Section 10, the savings clause. It couldn't be clearer, 10 versus 11, the two savings clauses. One, the savings clause is that the state is going to be authorized to continue to regulate and adopt and implement regulation on greenhouse gas
The state
emissions.
hasn't actually done that yet. It has, as part of this initial legislation, it hasn't actually created any specific emission standards, has it? Like, you can't go above this level, which is what the city did.
Yes, but Your Honor, it established a special expert entity under state law and an advisory council to do just that. And the
hasn't
city
that
jumped the gun.
Going to that, hasn't that advisory council indicated that it looks favorably upon the city legislation?
No, Your Honor. What it did was it said it welcomed the city's input. It did not say, oh, the city got it right. In fact, this is
It
an
also
area.
didn't say the city can't be doing this, this is inappropriate, and we're going to knock this out.
Your Honor.
It didn't indicate that in any way.
It's what the state legislature intended, not what an advisory council or what member of an advisory council may have said. The state legislature clearly intended to preempt the field. The use of this kind of language, the people who signed the bill, the governor and others, use the same language consistently. Statewide comprehensive program to regulate and implement rules and procedures for reducing greenhouse gas emissions.
So how do
That's
you
not something that.
How do you interpret the language in Section 11, the other language?
Yes.
Other
well,
requirements
yes.
for protecting public health and air and water quality?
Yes, I was coming to that, Your Honor. You have to, the two savings clauses, you have to read 10 and 11 together. Section 10 expressly reserves to the state the ability to continue to adopt and implement regulations relating to greenhouse gas emissions. Section 11, if I may.
Let me ask a specific question, though, because this is relevant. Greenhouse gas emissions is such a broad statement. How does that not just encompass Section 11, state air and water quality requirements and other requirements? Why isn't that all one and the same?
Because, Your Honor, in fact, they're making an express distinction in 10 and 11, because in 11, they talk about other areas. They talk about other requirements.
Isn't emissions everything?
Not greenhouse gas emissions. There is a difference between measures to reduce greenhouse gas emissions and measures that protect the environment and public.
Because in section 10 says other requirements for protecting public health or the environment?
Yes, it does say other requirements for protecting public health and the environment, other than 10,
Greenhouse.
which says greenhouse gas emissions. It couldn't be clearer to me as I read the plain language. And therefore, not only was the lower court wrong to grant a motion to dismiss, on the plain language of the statute, it seems quite clear it's comprehensive statewide.
Further, assuming that there is an ambiguity here, and that arguments can be made on both corners, how is further discovery going to help us clarify, or help you clarify to the court what that ambiguity, how that ambiguity should be resolved, assuming there is an ambiguity, which I know you're not.
Two points, Your Honor, and I want to be crystal clear about this. It was inappropriate to grant a motion to dismiss on this well-pleaded pleading, but we would be entitled to move for summary judgment or judgment after they answered. Here, we think the statute is clear on its face that it was intended to be comprehensive statewide. But even if there were ambiguity about it, yes, we could take discovery. Governor Cuomo, former Governor Cuomo, an old friend, I would have him give discovery on what he intended when he signed that. I would take discovery to confirm, if there's any ambiguity in the statute, that the state intended to preempt the field. But I may never need to do that. I may be entitled to summary judgment or judgment on the pleadings once issue is joined, but to have dismissed this case, absolutely wrong.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the court, Amy McCampbell on behalf of the city. Your Honors.
We are at the stage of 3211. So why not proceed? I don't know whether Governor Cuomo actually, assuming there's an ambiguity, which again, I'm not stating there is, that you would necessarily take his deposition, but why not proceed to discovery on these issues, on the presumption issues?
So this is a facial challenge to the local law, and then it's clear that these are pure questions of law. The cases we said in our brief, the Amazon.com case from this court, which was affirmed by the Court of Appeals, and also the Garcia decision from the Court of Appeals, those show that it's appropriate to resolve these kind of facial challenges to statutes at the motion to dismiss stage.
Well, isn't there, in terms of just a facial sufficiency, if you look at the legislation, why doesn't that legislation on its face create some ambiguity as to the issue of field preemption based on two things, which is first, that it says it's comprehensive, which is a sign of field preemption, not conclusive, but a sign of field preemption, and the fact that there could arguably be some ambiguity in reading Section 8 and Section 10 and what the word other means, because it does clearly say on its face that nothing in this act shall limit the existing authority of a state entity to adopt greenhouse, but it doesn't say anything about city. And then the next section about the city says it won't prevent the city from, or local laws about state air and water quality, but it doesn't say anything that the city can do greenhouse gas. So why isn't that enough to at least create a facial ambiguity in the statute as to whether or not this field preemption?
Sure, Your Honor. So 3 points in response to your question. First, the standard is not whether there's ambiguity. The standard is the plaintiffs have to show that the legislature clearly evinced an intent to preempt local legislation, and they simply can't show that. That's a Jansen decision from the Court of Appeals. Second, with respect to your point about the comprehensive statement. So this law, now the
what happens if we can't decide from the face of the statute one way or another whether or not there was meant to be field preemption, which is what you'd have to do on a motion to dismiss. You'd have to say the legislation itself is so clear that there's no question that they did or did not intend.
Well, the question is whether the plaintiffs can show that the legislature clearly evinced an implied preemptive intent, and they can't show that.
You move to dismiss, so the burden is on you to show that there's clearly not preemption.
And it's not, and I can address. Yes, and I can address your point. So in the language about the statute being comprehensive, so sure, there's that statement in the preamble that this is a comprehensive program, but this is not at all comparable to other situations where courts have found implied preemption when the legislature itself has enacted a comprehensive regulatory scheme. This is an aspirational statute. It doesn't set any requirements on any private actors. And here we are 5 years after it was passed, and there's still no requirements for any private actors to do anything. It sets a framework for future regulation. And there's no cases plaintiffs have cited where any remotely similar law has ever been found to impliedly preempt a field. Section 10 and Section 11. So let's talk about that. So Section 11 says that nothing in this act shall relieve anyone of compliance with any applicable laws. So to start with, it's perverse that plaintiffs are arguing that these two sections somehow relieve them of compliance with Local Law 97, because that's expressly contrary to exactly what Section 11 says. Now, their argument that Section 10 somehow undermines that is incorrect. Section 10 says something else. Section 10 says that nothing in this act limits the existing authority of a state entity to adopt and implement greenhouse gas emission reduction measures. So that makes sense that the state specify that in Section 10, because other provisions of the state statute expressly delegate such regulatory authority to other state agencies. So what the state is saying here is that even though we're delegating greenhouse gas regulatory authority to agencies, including DEC, in this statute, to the extent any other state entities already have the authority to regulate in this field, this statute doesn't limit that.
Well, wait, if you read Section 11 and Section 10 together, right? And so Section 10 says nothing in this act shall limit the existing authority of a state entity to adopt and implement greenhouse gas emissions reduction measures. Could you not conclude that Section 11 applies to local laws other than greenhouse gas emission reduction measures?
No, Your Honor, because plaintiff's argument relies upon them saying that other in Section 11 refers all the way back to Section 10, a different section of the statute. And the natural reading of Section 11 is that it refers to the last antecedent. So Section 11 starts by saying, nothing in this act shall relieve anyone of compliance with other laws, so any laws other than this act.
And other requirements for protecting public health or the environment.
Yes, and the example is including state or water quality requirements, or other requirements for protecting public health or the environment. So other in addition to the example of
That's not inclusive. I mean, excuse me, that's not exclusive. I mean, couldn't other requirements for protecting public health or the environment include other things as well, as plaintiff is asserting?
Well, again, Your Honor, the section says nothing shall relieve any person of compliance with any other applicable laws. So any other laws other than this act, the State Climate Change Community Protection Act. And that's exactly what other refers to in Section 11. And we have other evidence here that there was no preemptive intent. So first of all,
Let's go back a minute. Now, what about the fact that 8 could have said nothing in this act shall limit the existing authority of any state or local entity, but it doesn't. It's omitted. So it only says state. Why isn't there at least an argument that creates some uncertainty whether they also meant a state or a local entity from adopting and implementing greenhouse gas emissions reduction measures?
well, Your Honor, Section 11 makes clear that all other laws remain.
But why isn't there an ambiguity, at least, as to whether other refers to other than greenhouse gas emissions? Well, how can we decide conclusively, just looking at the facial words of the statute, that other doesn't mean other than greenhouse gas emissions?
Again, Your Honor, it refers to the last antecedent, which is nothing other than this act, or nothing other than state or water.
This act is about greenhouse gas emissions.
This act is the state climate community, so all other laws still apply, even after this act is enacted. It's the broadest possible savings clause. That's the intent of Section 11, is to preserve the applicability of other existing laws.
Thank you.
Your Honors, I think you had it exactly right. At a minimum, it is ambiguous. I think the proper reading of 10 and 11, and by the way, they're the savings clause. It's Section 10 and Section 11. They're supposed to be read together, okay? That's the way I read a statute.
My only question is, assuming there is an ambiguity, I'm not clear how to reconcile or how to really determine exactly what was meant. I mean, I know you said, you could call this legislature, you could call that legislator, but you would then look at the legislative intent. I'm not sure what other discovery there would be to assist in the ambiguity.
So Your Honor, I think the case law would tell you in a circumstance like this, not what respondents just argued, but that if there is ambiguity, that you look at legislative history, you dig down, and there may be circumstances where the party is responsible for propounding the bill or authorizing.
That's all contained in the legislative history, though.
And we've not yet had the chance to fully, go through that too. But you do have circumstances where there could be testimony that is relevant, or there could be other sources that inform. Now, on the plain reading of this, I think the proper plain reading, when I get my chance to make a motion, is that you read the two in concert, and other means what it says, that 10 applies to greenhouse gas emissions that the state intended to comprehensively regulate, and savings clause in 11 is about other requirements for protecting public health of the environment. But if I have to fill in any ambiguity, I should have a right to at least try to take discovery in that regard.
Mr. Mastro, just a couple other points you raised.
Yes, sir.
You're unhappy with the second, third, and fourth causes of action being dismissed as well.
Absolutely.
So let's take the one where you argue retroactivity. The language of the local law suggests future conduct, not retroactive conduct. True?
True, and I'm really glad you asked.
Secondly, excessive fines. That's a very tricky one, because when you facially challenge, or when you challenge the constitutionality of a statute, which you do facially, it's a very high burden. And you agree, the case law is very clear on that. So,
I do, Your Honor.
So worst case scenario, assuming you won't, let me say it this way. Do you agree that later on you might have the possibility to do an as-applied challenge once a sanction is imposed, arguendo, in the future? Because much of your case, you describe how your co-ops are going to go under with millions and millions of dollars of sanctions because of the impossibility of being able to meet the local law standards. I got that. Would you agree that you still have another bite at the apple later on if that were to occur?
I would agree that that's the case. Now, if I can go back to where you started and just briefly explain a couple of things. It is a retroactive application because my clients, many owners of property, were complying with the law, upgrading their properties. Glen Oaks spent huge amounts of money going to solar and other things to, on a voluntary basis, comply with the laws that existed and improve their energy efficiency. And then, boom, a year later, they had it pulled out from under them. And now they have their existing structures. This is not just prospective. They invested the millions of dollars into energy efficiency, and now the state is saying, the city is saying, as opposed to the state, which was relying on a voluntary program, the city is saying, too bad. Now your systems, which you can't get rid of without bankrupting you, all right, too bad, we're just going to fine you every year, all right? That's why it's retroactive. It's a future penalty for something you can't fix that you've complied with the law before to do it right, number one. Number two, about the fines themselves. That explains why they are draconian, and this is a facial challenge, because it's a problem that they can't possibly fix without a solution. Yes, we could challenge the as applied later, but the fact of the matter is, across the board, this is a draconian, unfair system that for people who were complying in good faith with the law and even upgrading their systems, now they're going to get fined every year and they can't do anything about it. So my client shouldn't have to wait to be fined for that. Thank you, Your Honors.
Thank you very much. Bradley v. St. Barnabas Hospital.
Thank you, Your Honors.
Yes, whenever you're ready.
Good afternoon. May it please the court, my name is Samantha Quinn. I represent the defendant appellant, St. Barnabas Hospital. I would like to focus the court on the issue of proximate cause and specifically start with the third cause of action, which is for wrongful death. The plaintiff's expert claims that the alleged failure to document and stage decedent's pressure ulcers and failure to turn and position her more frequently caused her injury, including her subsequent.
So the cause of death was listed as pneumonia?
It was.
Renal failure, pneumonia?
It was at record at 396, hospital-acquired pneumonia, end-stage renal disease, hypertension, age-related illness.
Right, and the expert report talked about ulcers but your argument is that there was no causal relation between the ulcers and the renal failure and the pneumonia?
Well, her end-stage organ failure contributed to the ulcers, but there is no relationship between the ulcers and her ultimate death. I mean, to state that her death was caused by the failure to turn and position her or to document staging and treatment of pressure ulcers is completely specious, and it's totally unsupported by the record. 2 days after her admission, and by the way, the plaintiff's expert just picks up on April 12th of 2016 without going back to 30-year history of hypertension, 10-year history of end-stage renal disease for which she was getting dialysis 3 times a week, and an acute ischemic stroke in 2014, a malignant mass found in 2014, another ICU admission in 2015 for altered mental status, advanced dementia, weight loss, where it was noted she had advanced vascular disease.
Condition when, I mean, what's really about, what was the condition when she got admitted the final time? Was she already terminal at that point, diagnosed?
Yes, and they had been talking about palliative care and hospice for over a year. The alleged pressure injuries were previously present, all of them. But the 2 issues that I think are most important, first of all, that wrongful death has not been proximately caused, but even with respect to the worsening of these pressure injuries, the failure to document can never proximately cause an injury, and that was a huge part of the plaintiff's expert's position. Again, also, the failure to turn in position more frequently has been found by courts to be too vague and speculative to constitute.
Isn't it really a more nuanced standard than that in terms of the cases? And some of the cases, it appears the defendants are successful in getting these cases dismissed, and sometimes they're not. It seems to be very dependent on the specific records of the case, what evidence the facility did or did not provide as to the procedures and whether or not they were actually followed, what explanations are given by the doctor and whether it's an explanation for the other symptoms. It doesn't seem like there's any bright line rule about whether or not these kind of cases could go forward. And what about in this case that there is not a lot of evidence in the record about exactly what procedures St. Barnabas did or did not follow in this particular case in terms of the treatment of these wounds?
Well, I agree with you, there isn't a bright line rule, but I would argue that the court should follow its precedent in the Craig and Vargas cases where similarly ill patients with multiple comorbidities develop pressure ulcers, and the expert opinion, which didn't acknowledge the significance of the comorbidities, was deemed to be too speculative.
Right, but what about in this case, the expert did address the comorbidities in a way that the experts in the other cases didn't address them?
I would argue that he didn't. I mean, this exact same expert opinion was analyzed by Judge Spodek in the Colville case, and she held that the opinion as to proximate cause was speculative and factually unsupported because the expert didn't actually address the impact of the multi-system organ failure on the skin, which is the biggest organ in your body. In this particular case also, the expert didn't address the fact that the Citadel bed was set to turn in position every 30 minutes. So
Yeah, but there were gaps. I think one of the concerns here, putting aside wrongful death, I understand that issue, but there's a discrete claim that the decedent suffered from the pressure ulcers, standalone. And then the question becomes is, while the hospital is busy trying to keep her alive and do all the wonderful things that the hospital does in these kinds of scenarios with a patient like this with so many comorbidities, did they implement all the different protocols to at least minimize the ulcers getting bigger, worser, more painful, so that, and we know that even if someone's in the ICU and they're intubated and they may not be able to vocalize, there is a great deal of suffering with these kinds of ulcers. That's the claim here, pain and suffering, putting aside the wrongful death. So the plaintiff's expert here is raising an issue. There are gaps, like you make reference to the citadel bed, but there's really nothing else to show that the plaintiff's on the citadel bed is operating XYZ, or debridement was done, although there was one note on the record about debridement of one particular ulcer, but regularly monitoring and checking the ulcers and changing the dressing and manipulating and doing all this stuff. I mean, the protocols are pretty much extensive. The question is can you say on this record that based on the nurse's notes, based on all the notes here, that there's a sufficient basis to say we must win on summary judgment, given the gaps?
I would, Your Honor, because essentially that the plaintiff's expert ignores the fact that this citadel bed, which is meant for an ICU patient, is turning and positioning the patient every 30 minutes. It's set to do that. He just talks about the fact that it didn't specify what mattress was used for the citadel bed, but he never addresses the fact.
But he does address other issues. I mean, we don't know the gender of the expert, but the expert does talk about other issues. Talks about the comorbidities, talks about as was mentioned, the lack of record keeping as to exactly what was done in terms of turning, et cetera. Talks about the lack of investigation as to whether these comorbidities led to or caused the ulcers or how the ulcers could be relieved. So, I mean, it's a little bit more involved, and the expert does, as I stated, go to speak about different things and does address issues. And I recognize your position as to the citadel bed, but there are other statements made concerning the positioning.
Understood, Your Honor. I see that my time is up.
Yeah, you have time on
If you want me
rebuttal.
to address it on rebuttal.
Thank you.
Excuse me. Good afternoon, Your Honors. Jason Levine for the plaintiff respondent. I just want to pick up on a comment that Justice Schulman said. There is this separate theory here of liability in connection with the failure to adhere to the standard of care resulting in the development and deterioration of these pressure ulcers. We acknowledge that, you know, the cause of death here was not the pressure ulcers. The death certificate confirms that, but these are separate theories of negligence and medical malpractice with respect to these pressure ulcers. And as the panel pointed out, the plaintiff's expert did, in fact, address the defendant's expert's opinion regarding the cause of these pressure ulcers. You know, the defendant's expert took the position that these pressure ulcers were unavoidable by virtue of the comorbidities and the condition of the plaintiff upon her admission. Again, the plaintiff's expert addressed this and said he disagreed with it, pointed out that what the cause of these pressure ulcers are, which is unrelieved pressure, and that the actual conditions that the decedent had, such as hypertension and some of these other conditions, do not cause pressure ulcers. So we would submit that, you know, based upon these opinions in the record, which were based upon the expert's review of the, multiple thousand-page hospital record, the pleadings, and the other proof in the record, the Supreme Court properly concluded there were issues of fact raised by this expert's affidavit, which, as in many cases in this case, was to the extent that it conflicts with the defendant's expert, raises issue of fact, which precludes summary judgment. And to the extent that, defendant attacks this expert's affirmation that's been rejected in some other cases, we would submit that merely goes to...
A number of other cases, apparently.
Again, we would just submit that, those are different facts in those cases, and that would be a question of credibility for...
Apparently 5.
I'm sorry, Your Honor?
Apparently 5 other cases. It was rejected in 5 other cases.
Right. Again, we would submit that would be a question of weight, not admissibility, and a question of credibility for a jury determined trial. Unless the court has any further questions, we'll rest on the arguments in our brief.
Thank you.
Thank you.
I would just like to address one point. Counsel mentioned that the comorbid conditions don't cause pressure ulcers, and that specifically was addressed by Justice Spodek in that Colville case, where she mentioned that the same expert, same essential opinion that the failure to stage these ulcers over time is a cause of negligence. Oversimplified assumption that unrelieved pressure causes pressure ulcers. Certain comorbidities, when considered in isolation from other comorbidities, do not individually cause pressure ulcers. It is true, however, the skin is the largest organ in the body, and its integrity depends on the function of all the other organ systems for nutrition, circulation, and immunity. What our expert said is not that hypertension caused pressure ulcers or that end-stage renal disease did. It was the combination of all of these comorbid factors and the fact that she came in with these injuries to begin with and was basically in end-stage organ failure at the end of her life and unable to heal. Thank you.
Thank you. Thank you both. DirecTV versus Nextstar Broadcasting.
May it please the court. Good afternoon. I'm speaking for Nextstar, and I wanted to begin by focusing on the contract claim. There's a contract claim and a fraud claim in this case. Reviewing the briefing for this argument, I was struck by how we'd kind of gotten down in the weeds on the two key contract clauses, and I wanted to spend a few minutes just getting out of the weeds, a little big picture. There are two provisions, Section 8, Section 7 in this contract, and their interaction is what gives rise to this contract claim. Section 8 starts out with a couple of formulas. It's got a formula for how much they owe us if it's a station with a network, and that's defined to be like ABC or CBS or whatever. Then there's a second formula after that. It's for sort of second banana networks like the CW and another one that I frankly wasn't familiar with. And then there's a special provision about the TV station in this case, WHAG. And it says that they're going to pay us, DirecTV will pay us, a kind of a plug number of 220,000 subscribers, and they just put that number in there to have a number in there. Pages and pages of this agreement go on after that for how you calculate viewers. But here they just got a number, and they said we're going to take that number and we're going to charge the network rate, so the first of the two formulas, until DirecTV launches the station. That's how it concludes. And it goes on with some more administrative matters after that. But Section 8, it's got a formula for networks, it's got a formula for second banana networks, and then it's got the clause that we say is controlling of this case, the one about WHAG, where they say, here's what they're going to pay, here's the number of people it's going to be, here's the rate it's going to be, and here's how long it's going to be until they launch it. And of course, they ultimately did not launch it, and so that's the basis of the contract claim. The response to that made by DirecTV is, but look on the previous page. Look at Section 7. That's great that you've got Section 8, and it has that provision in there, but Section 7, they say, talks about the situation in this case, where a station loses network affiliation. And that was a position ultimately adopted by the trial court here. But Section 7 just doesn't say that when you get down into it. It's got 3 sentences. The third is an administrative thing that's not relevant to this case. The first says the parties acknowledge that station affiliations are the essence of this agreement. And then it says, if a station changes network affiliation, it shall be subject to the license fees set forth in Section 8 for its new network affiliation. End of sentence. That's all it says.
So why doesn't that mean if the new affiliation is no affiliation, it's 0, which is what the contract states?
Oh, it's not there.
It's 0.
They have a fee for the big network, they have a fee for the little network, and then they go on to talk about our station and a couple of other ones. There's nothing in there about losing affiliation. What there is a provision about WHAG, where they just didn't want to deal with it. They were trying to sell this massive number of stations. It wasn't important.
I'm going to ask you to move on to what I think is the much more difficult question, which is the fraudulent inducement,
Sure.
and whether or not the plaintiff is or is not entitled to summary judgment on the fraudulent inducement.
Fair enough.
But my specific question is, now that the NBC agreement has come to light, and the NBC agreement says that there is going to be no further extensions, what is incorrect about plaintiff's argument that that is enough to entitle to them to summary judgment on the claim that you knew, your client knew at the time that the agreement was entered into, that there was no way there was going to be any further extensions, and therefore fraudulently induced them to agree to this $220,000 unlaunched station fee?
Right, so there is conflicting testimony about that. I know the agreement, that document says that. But this is in a business context where people don't generally lose affiliations, and our witness's testimony said, I thought we might be able to do something.
What is the underlying factual underpinning that supports that? With the agreement on its face is clear that it says no further extensions.
But-
Why should the court accept that assertion?
And if I could just add, that in addition to the agreement, you have the back and forth emails between the CEO and the COO in which it's clear that they anticipate that the affiliation is going to end.
So that evidence is there, and the court can construe it how it wants to. I think it has to be construed, though, against the people involved in it, testifying about what they thought the overall situation was, which was that they might be able to save this yet. And
what is that based on? The feeling, the hope, the thought that they could save this in light of the email communications, in light of the contract, the agreement that said it's going to end on a date certain. What is the basis for that thought?
Because in this industry, things just work out. The evidence shows that the great majority of these network affiliation disputes, these network affiliation situations resolve with continued affiliation. And sure, people say
Even in
things,
cases where you have a contract that says it's going to end on a date certain?
the record doesn't speak to that one way or another.
It does
just
not.
says this business situation tends to work out. And our people participating in those thought this may yet work out.
Did your people say during the deposition, I forget the gentleman's name, did he say, well, I thought it was going to work out because in the past it's worked out, or in this industry it normally works out?
I don't recall what he said exactly. There's a lot of back and forth with him.
Right, but I don't think that's what he said. I think he just said, I thought it was going to work out.
He's been in this industry forever. He knows how the industry works.
So
That's
he
why
could've-
those experts testify.
So he could have
just to give
said that.
context.
He could have said that.
We have the record in front of us that has all these pieces. And in the context of an industry where that's the reality, the people that participate in that industry know that, and that's the way they approach this sort of negotiation. By the way, all of this is protected by confidentiality agreements. And there's testimony about that as well, that if someone had called up, which they never did, by the way, none, never, no inquiry ever, about this supposedly material contract, if they had, there's a real question whether we could have said anything, or we have just had to say, sorry, can't answer that, bound by
Yeah, but there's a
confidentiality.
question whether or not you could have disclosed it, and whether you fraudulently induced them to agree to it knowing, but that's a different issue.
Well, there are different elements of this claim, right? There's fraudulent, whether it's true or not.
The fact that you couldn't disclose to them, though, it wasn't going to end, doesn't mean that you really believed it wasn't going to end, it was going to end.
Well, the record on that, I think, contains conflicting testimony. Our guys.
What exactly is the testimony that you are relying on to support that there is a factual dispute as to what your client did or did not know about whether this was going to be ending?
Well, it's what we've just discussed. There's our Mr. Sook's testimony, there's the industry testimony that the experts provided, and there are these various email communications. And you can look at those, and you can construct their story, and you can construct our story, and people need to speak to be able to get to the bottom of that. Our guy needs to talk, the experts need to talk, and we need to understand the full
But your guy
context.
did talk. He was deposed. Wasn't your client deposed?
He said, and he said he thought he'd be able to work something out. That's all described.
What more is there now? This is a motion for summary judgment. What more is there? He already spoke.
Well, I'm a little confused by that. Is the question what?
The question is, this is what is before us now. So we have to base the determination as to what is before us now. He's already stated as to his understanding, the intent, et cetera. So why is that
right? Okay.
Sufficient, right?
I think the critical element of this claim is justifiable reliance. And this court's precedent, we've got two cases we cite. I just want to say their names before I sit down, because I think they put the hierarchy here. It's a case called Venture, there's no E on it, and a case called Graham Packaging. And they say even if there's a duty to disclose, they still have to ask. In the absence of that question is sufficient.
Right, and I was going to ask you that because you just said that there was a confidentiality agreement and therefore you would not be able to disclose. So even if they asked, and if they had to do, because I was going to, say doing due diligence and, what investigation did they undertake? What investigation should they have undertaken? You just stated that you would not have been able to respond.
So in that case, we didn't mislead them. But if it is the case that we can only say we can't tell you, that's a material answer, right? if it's so important to them, if it's so material that they have to know, and we say, sorry, we can't tell you, they know there's something going on.
So that would have been enough. So your argument is that if they asked you and you said, oh, we can't tell you, then it's on them to make a determination as to whether they're going to proceed
That's
or
why
not.
this court's cases say it's so important, because saying I can't tell you is itself a material fact for something that's supposedly as material as they say it is.
Thank you.
Good afternoon, Your Honors. You know what they didn't have to do?
First of all, I have a question for you, but first you have to introduce yourself, I think.
John Pressman from Baker Hostetler on behalf of DirecTV.
So I would like to go right away to the issue of the fraudulent inducement. Your argument is that we should find as a matter of law that the intent was to induce you. But what do we do then with the testimony of their CEO that he believed up until the last moment that there would be an agreement reached as to a further extension, and that he diligently worked until the last possible second to extend WHAG's NBC affiliation. Based on that testimony, which is pretty unambiguous, that he believed it would be extended and he was working to have it extended, and that they often did agree to extend it, and that was the norm, why isn't that enough, particularly in light of the very high standard on fraudulent inducement, to create a factual issue as to whether or not there was an intent to misrepresent things?
Justice Kern, I want to come right at that question, and I want to do so because I think Your Honor's question underscores really the determinative issue in this appeal, and I would say in this case. And that is, can a party avoid summary judgment by relying on demonstrably false, self-serving testimony, in this case given by its own CEO? And what Your Honor is referring to, and the answer, by the way, to that question is no. And this court has held that repeatedly, most recently in Carthen v. Sherman. And there, this court stated that there are rare instances where credibility is properly determined as a matter of law. And it cites the case of Finley v. Erie and Niagara. And it says this court is not required to shut its eyes to the patent falsity of a claim or defense. Now, the testimony, Your Honor...
That's a very, very rare circumstance. I was actually looking. I didn't find any summary judgment being granted to a plaintiff on a fraudulent inducement, and I did try to research that. I didn't find any cases that actually granted summary judgment to a plaintiff. Although it says ordinarily, it's a question of fact. But you can tell me about it in a second. But my question to you is, why should we find it inherently incredible, his representation, that he was continuing to negotiate, because the norm in the industry was, and this seems to be undisputed, that it was unusual for an affiliation to be terminated? Why should we, not the jury, but a court, make a determination as a matter of law that it was inherently incredible that he maintained a belief that there might be an extension where that's the norm, that somehow an agreement normally was worked out to have an extension?
Justice Kern, I want to address that question in two parts. I want to talk about the facts upon which your question is predicated, and then the law. So here are the facts. That entire defense is based on 3 lines of testimony from Perry Sook's deposition. And here's the exact testimony. He was asked, did NBC ever give you a reason to believe you were going to get that extension? And here was his answer. They never said yes, but they never said no. And we were in dialogue on the renewal until the expiration date, at which time it expired.
So they were in dialogue.
Here's the problem.
But did he ever say that it was the norm, or this is what occurred in the industry? Was the industry norm?
Justice Weber never gave that testimony at all. But here's the point with respect to the testimony, Justice Kern, because I understand that he says we were in dialogue. He said they never said no. Now, at the time he gave that testimony, we didn't have the NBC agreement. We had no way of knowing what the answer to that question was. After he testified, we got the NBC agreement. And if you look at the record, page 1197, it says expressly no. So that statement is a lie.
Well, why does that mean? Why does that mean that it said no? Because it said no at a certain time and place, that he couldn't keep trying in good faith to get them to change their mind and to say yes at a later date, even though they said no at that date, which parties do all the time in contract negotiations.
Understood, Justice Kern. But when we asked Mr. Sook as part of his deposition, and I would direct the court to record 1161, We asked him, can you identify a single written communication where you're having this dialogue? Answer, no.
Yeah, but again, I was going to say the no that he responded, the no in response to the question was in terms of the dialogue. It really was not, the way I read it, was not in terms of the actual agreement. So I understand, what you're saying. However, just to be fair, that was in response to the dialogue and not to the actual agreement, in terms of them never saying no.
His answer of no, if you're saying you're saying in the course of the dialogue. And so then we tested that, Justice Weber, and we said, well, okay, any communications that you can point to in writing, page 1161 of the record, no. Any verbal communications you can point to, no. We then deposed the 2 NBC witnesses, okay, who were in this alleged dialogue. Were there any communications about this affiliation being extended after that agreement was signed? They both independently answered no, not once. Nextstar, we served document discovery requests on them. They didn't select one page, did not produce one page to even indicate there was any such discussions. So the question really does come down to, Justice Kern, can you avoid summary judgment with false testimony? Can you avoid summary judgment on a belief?
You're saying we should find it to be his, because he does clearly testify that they were negotiating. He had a good faith belief. You're saying we should find that inherently incredible as a matter of law and grant summary judgment on.
That's actually what I see. My light is going off. May I complete my answer?
Please.
Yeah, and I also want to hear if you found any summary judgment cases granting summary judgment.
The answer is yes. This court has done it. The case of Knox v. Lakin, affirmed summary judgment, fraudulent inducement. The Scharf case versus Tiegerman, Second Department, summary judgment, fraudulent inducement. That case is very similar. They were trying to sell a house that they said was zoned for 3 families. They did not disclose the fact that the 3-family status was under investigation, and the court found that you could infer fraudulent intent because they tried to sell the house before. That investigation was an impediment to the sale before, and therefore they were motivated to sell, and they inferred scienter there and ruled for summary judgment.
But I wanted to ask, your friend had mentioned the fact that you never asked concerning the any agreement or any issues in terms of WHAG and NBC, and that if you had in fact done due diligence, you would have gotten the answer. Do you agree that if you had gone to them and asked them and they had said, because of confidentiality, well, we can't comment on that, that therefore that would have given you the information that you would have needed to proceed?
Absolutely not. And I want to say that point proceeds upon a false premise, because you know what they didn't have to do? They didn't have to put this program, this station, into the agreement in the first place.
In fact, you didn't want it in the agreement.
We didn't want it in the agreement. They pushed it on us. And so once they did that, as Junius, Court of Appeals case says, once you do that, once you leverage the NBC affiliation, you have a duty to complete the factual picture and give all the information. The other thing is we did ask, and we cite it in the record. We sent an email to their general counsel in advance of the signing of the agreement, said, let us know, we have questions about affiliation changes. She advised us of 2 stations that had changed affiliations, and she didn't advise us about WHAG. And just to your point, Justice Kern, if I may, the cases are Knox and Scharf, in which fraudulent inducement has been granted summary judgment. And with respect to the unfounded belief, that's exactly what this court ruled in 2019 in the Carthen versus Sherman case. It said, if you have somebody just expressing testimony and it's not corroborated and in fact disputed by other portions of the record, you don't have to accept that. This court does not have to close its eyes to patently false testimony, and that's what this was.
Thank you.
Just to react to this case, it describes it as dealing with a home investigation. If that case had had expert testimony saying that that type of investigation fizzled out and went nowhere 99% of the time, I bet that case would have reached a different result. The testimony about the record here about the industry is distinguishing from the matters he is citing. And falsity, true, false, up, down, left, right, there must be intent tied to it. You've got to be telling a lie. an intentional falsehood, for there to be fraudulent inducement. And Supreme Court said even its review didn't see clear and convincing evidence here. It sees this dialogue discussion. It sees the broader business picture here where no one really, this station isn't central to anybody. And there's just no reason for the intentional lie to be told other than some desire to make money, which is insufficient as a matter of law. So my opponent's enthusiasm about the depositions, I think, falls on the weight of what the record actually is, but it doesn't go far enough to discharge the burden that he needs to satisfy to establish what he's seeking in this case. Also, back to the House case, his example of the home investigation that's not disclosed, if there had been a sign in the front yard that said there's a house in this neighborhood that's under investigation, it will wrap up in a year, that would probably have changed the result as well. That, of course, is what we have in our 10K filing that says one of our stations is affiliation agreements running out in the next year or so in 2016. That's the question, that's the red flag that they never read because they never looked at it and they never followed up on and never asked about that.
Your friend just stated that they did inquire as to station affiliation.
Not to that statement. In the time, we've discussed it in our briefing, the time and place and context of that is distinct from the point I'm making. I acknowledge that he says that, but I don't think it's pertinent to this approach to the justifiable reliance issue. And that gets you back into this court's cases about reliance again. If it was really that material, we're not going to tell you. They should have heard that.
Thank you. Thank you both. Irani v. I'm sorry. Oh, you have it, but I apologize.
Yes, sorry. So quickly, the fact that Nextstar still relies on that statement in their 10K to say that some of their stations are expiring and gives dates is nothing less than astonishing because it doesn't identify WHAG, and what they have neglected to raise at any point in their briefing is the statement below it that says, we fully expect these station affiliation agreements to be renewed upon expiration, showing that they not only defrauded DirecTV, they committed securities fraud. This was in a 10K report 2 years in a row, and they state that we fully expect, after they knew that the expiration was done. I would also point just quickly, if I may, and I see the light is on.
How have you met your burden of establishing there's no way you could have found out that information?
No.
How have you met your burden, since you're moving for summary judgment, of showing there's no way that DirecTV could not have found out that information, that the agreement was expired?
Nextstar's conceded it, because if you look at the record, Ms. Ryder, their general counsel, stated on the record 1386. She also says it at 1188 in the record. If you look at 1188 and you look at 1386, both times, in 1188 in particular, she says, we would not have given them the document if they asked for it. We would not have revealed that information.
Is there no other, have you established there's no other way you could have gotten
Absolutely. She says it's totally confidential. In fact, even in their filings to the FCC, they redact the term information. But really quickly, and it's critically important, is this. When you talk about whether or not Mr. Sook truly believed that these discussions were continuing and held out hope, look to the 2 emails that we have submitted. And Justice Weber, you cited one of them. When he talks to his COO, his Chief Operations Officer, this is before they sign the agreement. He says, time to start planning for the post-NBC era at Hagerstown. That's where WHG
But your friend said that doesn't really go to his intent because it doesn't show any intent to defraud or any intent to conceal because, again, he believed that with further negotiations and attempts, he would be able to work it out.
Well, at the time he signed the agreement, he sent a second email to his VP of Finance, and he said, what's the total value in the contract? And this is in the record, and his VP of Finance says, this is the number, assuming WHG remains affiliated with NBC. Let me know if that is a correct assumption. Mr. Sook, contemporaneous essentially with signing the contract, says at that point, it is not. It will go to unaffiliated June 30th, 2016. That is a smoking gun. That disproves it. Thank you.
Thank you. Thank you both. Irani v. City of New York.
Good afternoon, Your Honors. Stephen Kirkpatrick for Appellant. The first issue on this appeal deals with the predicate notice of termination, which was required before the underlying HPD proceeding could be commenced. And that notice of termination unlike most notices, was not signed by the cooperative housing company's officer, but rather by an attorney. And it was based upon an authorization. And the problem is that that authorization...
Is this the ancient Kentucky Fried Chicken analysis?
Kentucky Fried Chicken, Your Honor. It's exactly, that was the lead case that we cited. So here we have a notice, an authorization that was signed 15 years before, and where the prior co-op president who signed the authorization died 5 years before the authorization was used. And in addition, what we have is this co-op housing company is East Midtown Plaza, and East Midtown Plaza has been in the process of undergoing privatization for at least a decade. And as a result of all of those facts, there were serious concerns that this notice of termination really may have been, in this whole proceeding before HPD, may have in fact been instituted.
Did it give fair notice of the charges? The notice of termination, did it give fair notice of the charges?
The notice of termination set forth the basis for the termination, yes.
So isn't that the, one of the considerations is whether or not it gave fair notice of the charges, whether or not, therefore, petitioner would have the ability to prepare and go forward?
That's a different issue, Your Honor. The issue that we raised is the reliance upon that notice. When a tenancy is going to be terminated, as the Court of Appeals in Kentucky Fried Chicken explained, there has to be a basis to know that this is really a valid notice. And when you have a notice that is based upon a 15-year-old authorization where the authorizer died 5 years before the notice was given, that raises significant questions whether this was in fact a notice that was provided by the co-op housing company and not by HPD, which was another issue where in the prior HPD proceeding there was a 2012 letter that essentially showed that the matter originated because there was a directive of HPD to begin the case. And so we believe that this case was really effectively brought by HPD and then heard by HPD, and based on this improper notice of termination. That's the first issue that we had raised. The other issue, the next issue, is my client's confidential tax information.
Yeah, but the rules make it very clear that in order to establish a primary residency, the rules mandate that you submit not the numbers. They don't need to know the numbers. We know how it works. They redact the tax forms to make it clear that the tax returns are generated from the subject premises. That's part of the evidence that they need to consider, separate from other evidence, that you're maintaining the place as your primary residence and you're not subletting it to somebody else, and you're not somewhere else, as on the record before H.O. Lippa in London, when you really should have been in your apartment where your parents historically were there. So what's the concern there? It has nothing to do with confidentiality. The rules mandate it.
Well, the concern is, Your Honor, that...
And you don't challenge it. On this record, your client indisputably, for certain discrete periods of years, I don't have it in my head exactly, 2000-something, clearly did not submit the appropriate documentation to show that she was maintaining that place as a primary residence.
Well, on this record, that's a key term, because another argument that we made is that the record should have been expanded to include the prior HPD proceeding. But
why? It was discontinued without prejudice. It became a nullity. It's a brand new ballgame.
Well,
and H.O. Lippa didn't rely on what you claim was impermissible information from a prior investigator that was the underpinning of the earlier proceeding. Your focus is this one, and he made it very clear, H.O. Lippa, that there was reliance on independent information on this record that was developed, i.e. the missing tax returns and evidence showing that your client was in London or your client was unlawfully subletting, your client wasn't where she was supposed to be to maintain the primary residence under the rules.
The issue arose, there were some tax returns that were submitted, some.
Did not provide tax returns for 2009 through 2013 and 2015 through 2018.
Right. There was a 2014 and I believe at least one other. But this whole.
2014 or 2015.
Well, 2014 was submitted in 2017, right?
Right. There is also the tax returns that were submitted late. But there was also other indicia that she was not residing in that apartment and also that she had sublet the apartment.
Right, but to have this proceed in this way basically allows an investigator to, we believe, bribe somebody at the Department of Finance to get confidential tax information. It's undisputed that this tax information, my client's tax information, is confidential. And as a result of that improper investigation, that we believe illegal investigation, it's essentially a fruit of the poisonous tree issue.
But where on this record, sir? That's what I'm struggling. Let's accept what you're saying about the historic impermissibility or the unlawful collection of information through this alleged bribery. The HO LIPA, when the hearing officer made the decision in the second proceeding, was there anything in that decision that said that the hearing officer relied on the impermissible information? I didn't see that.
Yes, there was something, Your Honor. Included in the record was a copy of the so-called special tax investigation. It was filed as document number 3, NICEF document number 3 before the Supreme Court, and that was the investigation report that included the so-called special tax investigation. And that was in the record, and thus.
But the report submitted in the prior proceeding was not relied upon in the incident proceeding.
It was in the record, so.
But it wasn't relied upon. But you have time on rebuttal.
Good afternoon. May it please the court, Lorenzo De Silva on behalf of respondent HPD. So neither of the two claimed procedural defects that Irani raises excuses her patent failure to shoulder her burden to show that she had maintained this special resource, this Michel Lama apartment, as her primary residence. Let's talk about the notice. It was valid, and there's just 4 different reasons why there's no there. For starters, she waited until the last day of the 3rd day of hearing in the second proceeding to even raise this issue. The record actually reflects that she gave copies of the death certificates of her parents to the attorney for the housing company. This idea that she didn't know that the housing company was being represented by this law firm is so strange to me. That she got the authorization, or she got the notice, somehow went online and found the authorization, saw who signed it, and then looked up that they were dead, and then a layperson would say, oh, the only law firm that has ever been engaged to represent this housing company in connection with this complex, it must have been someone else. But even setting that aside, again, she knew what she was accused of, knew what she had to respond to, and she did respond with an attorney. Even setting that aside, she hasn't even responded to the restatement principles showing that it's just not the case that if I'm an individual officer of a corporation and I give an authorization, the corporation's authorization doesn't go away if I pass away. And even setting that aside, she had an independent obligation under the HPD rules to maintain the apartment as her primary residence, and she's done absolutely nothing to shoulder her burden on that. And even on the issue of, let's credit the claim that someone stole her tax information. Again, she had an independent burden to come forward with evidence that she was residing in the apartment, and she didn't file anything except for the one tax return belatedly filed, and after she knew she was already on notice. But even then, this fruit of the poisonous tree idea, she wasn't on the income affidavits for 2010 or 2011. Before the alleged theft of this tax information. The idea that that theft could somehow immunize her from having to respond and get to keep this $500 a month 2-bedroom apartment on 24th Street, that's a lot of chutzpah to me.
I was thinking what the consequence would be if, in fact, the tax returns were somehow stolen or there was unauthorized use of the tax returns. I was thinking, what would the remedy be for that? And is that a remedy that's something that HPD would deal with?
I don't believe it would run to HPD. There could be a remedy. It could run against the investigator, but two things. We're HPD, not the housing company, and we have the obligation to make sure that only those who are entitled to Mitchell-Lama apartments are in them. But even setting that aside, the only record evidence here is that the housing company didn't ask for, condone, or ratify this. Just the opposite. We never asked for this. We had, there were 4 independent bases that we outlined in our brief to bring the second proceeding. She did nothing to shoulder a burden once it shifted to her to come forward with her tax returns.
So as a Mitchell-Lama tenant or cooperator, she has to submit her tax returns. That has to be her primary residence as well.
That's correct.
And she failed to support or...
Across the board. Rational basis, and nothing excuses that failure.
Thank you.
As I said earlier, this whole matter arose because an investigator years ago, before the first HPD proceeding was brought, acted illegally. There's no way that this special tax investigation...
So again, how would that dissolve her responsibilities as a Mitchell-Lama cooperator?
Because she did file certain income affidavits. There were, I think there were years that tax returns were missing. But again, you have a situation where somebody is going to lose their co-op apartment because of improper activity of an investigator that appears based upon the 2012 compliance letter issued by HPD, where there was an illegal investigation.
But given the fact that HPD did not direct or ratify or supervise this investigator who you're arguing engaged in illegal activity, how then does that fall to HPD?
We don't know that, Your Honor, because another issue we raised is that we should have been granted by the lower court narrowly tailored discovery to look into those issues. It is unclear. The 2012 compliance letter was a letter from HPD to the housing company essentially directing that action be taken against my client, Isabel Irani. And we believe that as a result of that letter, we don't know who picked the investigator. We don't know these things. These are issues that we should have the ability to look into in limited, narrowly tailored discovery. And it is to be outrageous to have where you have illegal conduct, where an investigator can improperly get somebody's tax information, and then you're taking away somebody's co-op apartment as a result of that.
Thank you. Thank you both.
Lobby, be advised, court is over. Got 2 coming out. Yes, sir.